Good morning and welcome to the 6th meeting of the Equalities and Human Rights Committee for 2020. Can I ask that everyone make sure their mobile devices are switched off and put away. Item 1 is consideration of petition PE 1695 by Ben and Evelyn Mundell on access to justice in Scotland. The committee last considered this petition at our meeting on the 14th of November 2019. And we agreed to write to the Scottish Government, Human Rights Consortium Scotland, Just Rights Scotland and the Faculty of Advocates, and their responses are in our papers. We're joined this morning by Dave Stewart, MSP, who has an interest in the petition, and if committee are content, I would invite Dave to make some comments on it.
Thank you, Convener, and can I thank the members of the committee for allowing me to come along again this morning. I'm hopeful also that Mr and Mrs Mundell will be attending. They certainly were in Parliament yesterday, so I suspect they're on their way. If I could briefly summarise the petition and link...
I did notice the petitioners were waiting outside, and I just wonder if nobody sought to tell them to come in.
Shall I wait?
Thank you. My apologies.
Continue the question. Yeah.
Shall I wait until they come in?
I would just continue.
Okay, thank you. So if I could briefly summarise the petition from my last appearance in November and link it to the submissions received. I'll also make a recommendation for next steps, if that's helpful, Convener, to the committee. So the key underlying principle within the petition is really quite a simple one, and that is how do ordinary families on a modest income seek redress and justice? So, of course, the simplistic answer to that question is that families should seek redress through the legal system. We all know that, and we all understand that. That, of course, is the right answer, but what if you cannot get to first base? So the Mundells have been in touch in person or by phone with more than 50 law firms, but the vast majority will not deal with human rights cases. So that is problem number one. So problem number two is that many firms, many legal firms, restrict their involvement in human rights issues to issues specifically to do with prisoners or immigration only. And the third problem is that even when these hurdles are overcome, many firms only deal with human rights cases when there is substantial upfront payments. So, for example, one lawyer wanted an upfront payment of £25,000 before proceeding, and at that time that represented double the family's disposable income. So when I was here in November, I quoted Judith Robertson from the Scottish Human Rights Commission, who would be well known to all of you, and she said to the Joint Committee on Human Rights in Westminster about access to human rights, and I quote her, "It's difficult for anyone to take a case in Scotland. As I said, we have no powers to support anybody to do that. In fact, we are expressly disallowed." So what about next steps? Well, could I suggest that the petition is kept open until the Scottish Government issues its response to the consultation on legal aid reform in Scotland? I've also read carefully all the submissions. The Human Rights Consortium Scotland point out that the Scottish Human Rights Commission, as I've already mentioned, have no powers to take test cases. And they argue that the SHRC needs the power to give legal advice to individuals, and that would be a significant step towards improving access to justice on human rights. The committee will know that the Scottish Human Rights Commission is a parliamentary commission. Interesting enough, it's responsible to the corporate body purely for pay and rations, but its strategy is its own and Parliament's. But any change in its remit would, of course, require legislation to change its terms of reference. That may be something the committee wants to pursue. So I would suggest that the committee actually considers inviting the Scottish Human Rights Commission and the UK body, the Equality and Human Rights Commission, to a further meeting of the committee. As the committee well knows, and this is identified in the background papers, the EHRC does have the power to take human rights cases on reserved issues and can take court action on devolved issues, but only with agreement with SHRC. So to be honest, it's a bit of a chunky way of trying to organise things within Scotland. And I'm sure the parliamentarians at the time who thought up the legislation didn't really consider this was a bit of a problem. And finally, could I thank the Faculty of Advocates for its agreement, and I quote them, with the tenor of the petition that there is a significant lack of availability of legal services in relation to public law matters. I think they put it extremely well. That really summed up to me the problems within the petition. I'm obviously happy, as I did in November, to answer specific points. So although this on the surface seems complicated, it's not really. It's about access to justice, and I would use the Americanism, if you can't get to first base, you're not going to complete the whole circuit. So it's really, really important that we do look at this very carefully, and I'm very happy to answer any questions if I can.
Okay, thank you for that. That was a helpful summary. Do members of the committee wish to make any comment? Mary.
Thank you, Convener, and I'm grateful to Mr Stewart for his very helpful summary of the issues that are involved with this petition. And I know that Mr Stewart has been very closely involved with the Mundells since they initially took this petition out, and he has worked very closely to support them. And I won't go over the information that Mr Stewart provided, but I do think there is enough for the committee to recommend that we keep the petition open until the government gets issues its response to the consultation on legal aid. And I'm also persuaded by the comments that Mr Stewart made about perhaps taking evidence from the Scottish Human Rights Consortium and the UK Human Rights, because clearly this is a very serious and pertinent issue for the Mundells, but there will be other instances of families who are in the same situation, and it's something that we need to find a way to resolve. So I would recommend we keep the petition open.
Okay, lots of nodding heads around the table. Alec Gorman.
Thank you very much, Convener. Yes, thanks again to Dave Stewart for his very comprehensive assessment of the situation. It is a complex case. It is a very quite unique case, and it only applies to a very small number of dairy farmers. However, I think this Parliament exists to legislate for all of Scotland, not just the majority. So whenever we find cases of injustice, as in this situation, it is incumbent on us. I mean, it's not going to fall to anybody else to start making policy changes to bring effect to this. And I don't think we should shy away from that. So I support the calls to keep the petition open.
Angela Constance.
Thank you, and my appreciation to Mr Stewart as well. I am very much in favour of keeping matters open until we have the Scottish Government response. I am persuaded of the need for further evidence from the Scottish Human Rights Commission and the Equalities Human Rights Commission. I would certainly want to hear more from those bodies in terms of the benefits and how further powers for the Scottish Human Rights Commission could be secured to take on test cases. One of the things I would like to know from Mr Stewart, I'll certainly want to know it from the government and our human rights bodies, is the crux of the issue in the papers that were presented to committee is cases just now need to be plausible. There needs to be a prospect of success before legal aid or other assistance can be acquired. And there's a balance, bearing in mind we have to legislate for all of Scotland, because what will be untenable if there are cases that are then funded by the public purse that are less than plausible. So there's a balance in terms of ensuring proper access to justice, but there is also some financial aspects to consider as well. And it may be that this is something that Mr Stewart and others will have thought about.
Do you wish to come in on that?
Yeah, I think that's a very good point. I thank the other colleagues for raising the various issues. I note from the papers that one possible solution in the long term is for more delegation of European power to come within the Scottish legal system, which means then that you can get resolution at a lower level of the court structure, so to speak. And obviously, the less tiers you have to go through, the less costs are involved, and that obviously is sensible. And clearly, I understand there has to be balance of decisions when it comes to granting legal aid, but the point I would stress is it's not been for the want of trying. And the problem this family have faced is they just cannot get anyone to do it. That's basically been the difficulty. So, and we all want to avoid the fact that we have a millionaires legal system where the wealthy can access to justice and those who are less wealthy can't. And that's exactly what's happened here. And although it didn't spell it out, I probably should have stressed, Convener, that the legal issue that we're talking about here is the fact that the ring fencing mechanism was worth a lot of money to the family. I think I quoted a figure last time of 300,000 or thereabouts, but the record can correct it if that's not the case for the last time. So what we were arguing was that the quotas were protected under Article 1 of Protocol 1 of the European Convention on Human Rights, which is basically the right to have property. So basically these quotas had value and could be sold and transferred, but with this ring fencing that stopped the ability to do that, but effectively not quite bankrupt, but made the business non-viable, not just this family, but a number of individuals in the same area, because it referred to a very specific part of Argyll, which is very important. And the irony now, of course, is that many of the families affected at the time are no longer in business, for the very obvious point that this decision stopped their viability. And of course, lawyers will argue the only way you can determine if that was a right decision by government or a wrong decision is the court process. I agree with that, but we can't get to the court process to determine if we were right or wrong. And that is worth a lot of money. So I agree with all the points that have been made. And obviously, individually, while the committee is carrying out its work, I will seek a meeting about the specific case with the Scottish Human Rights Commission and the Equality and Human Rights, who I think have an office in Glasgow, if my information is correct. But we'll obviously see if there's anything we can do in the meantime. But I'm pretty certain we've tried to turn every stone in this particular issue. It's been exhaustive, and obviously that's been particularly Mr. and Mrs. Mundell. So there isn't any easy answers, but if the committee could open up, try and provide an answer for other families in the same circumstance, that would be doing a huge cause of good for human rights in Scotland.
Thank you, and I think we acknowledge that this is about access to justice for many. There seem to be nodding heads and agreement round the table to keep the petition open until the Scottish Government issues its response on legal aid reform in Scotland, with the option to invite petitioners and to take evidence from the Scottish Human Rights Commission and HRC after that happens. Is everyone agreed?
Agreed.
Okay, thank you.
For understanding.
Very welcome. The next meeting of the committee will take place on Thursday, the 19th of March. This will be a round-table follow-up evidence session on the committee's report into destitution, asylum and insecure immigration status in Scotland. And we now move into private session.